Appeals, First Appellate District of Ohio, with the Honorable Ginger Box presiding, is now in session. Proceeding.
Good morning and welcome to the First District Court of Appeals. We have two cases to be argued this morning. When I state the case, if counsel could please rise and tell me your readiness to proceed. The first case is C-240674, State versus Neal.
Candace Creer, ready to proceed, Your Honor.
Thank you.
Good morning, Your Honors. Jeff Meadows on behalf of Mr. Neal. I'm ready to proceed.
Okay, you can come up and sit at the table.
Thank you.
Uh-huh. Okay, the second case to be argued is, I'm going to butcher this and I apologize in advance. Shatiwi versus Abdul Massa.
Wishdan Sack here on behalf of Christina Shtawey, ready to proceed.
Thank you.
Your Honor, Ryan DeBraw on behalf of William Abdelmassi, ready to proceed.
Okay, thank you. And I apologize, I am sure I butchered both of your names. So the first case, are these lights working yet? They are working? Okay, I'll be keeping time on the lights here. Green means go, obviously. Yellow means you have about a minute left. And red means that your time has expired. You can come on up. And if you would like to reserve any time, please let me know.
Yeah, I'll reserve half the time if I may.
Okay. Whenever you're ready.
May it please the court? In my opinion, this is a fairly straightforward and simple issue. Mr. Neal had previously hired counsel before he engaged me to handle the discovery and potentially defending an OVI case in front of trial court. He was not feeling as if he was getting full information from his original attorney. Engaged me. I filed for discovery immediately. And it was my understanding that the case was set for pretrial. Prior to the sentencing hearings, on the docket it showed a 9/25 of 24 pretrial setting. I showed up and realized at that point that it was set for sentencing. I orally moved to withdraw. The trial court continued it for a couple days so I could file a written motion, which was filed, and immediately denied. My written motion, it was pretty brief. It cited some Ohio Supreme Court law, but also says that Mr. Neal did not feel that his original attorney was fully advising him of the merits of the case. State cites the 9 factors that need to be considered. Quite frankly, I think over half of them, namely 5 of them, are applicable in this case.
What's our standard of review here?
Abuse of discretion.
Okay, so can you please just tell me what your best argument is for saying that the trial court abused its discretion, that it was arbitrary or unreasonable?
Well, as I indicated, Mr. Neal didn't feel like he was being advised of the merits of the case from his original trial counsel.
Doesn't that seem like he just had a change of heart between the plea and the sentencing? I mean, he went through an entire process with multiple settings with competent counsel.
I don't want to, I'm not a fan of throwing fellow counsel under the bus.
But it was many different settings, right?
There's a number of different settings, all stating pretrial. Nothing to indicate that there was anything of substance that was done during any of those. Mr. Neal had actually advised me that he had never seen the discovery. This was not my first OVI case. I've actually handled thousands of them over the last 28 years, and that's how he ended up hiring me.
But it wasn't the other counsel's first OVI case either, right? And in this circumstance, the person at the time of the plea went through the entire plea colloquy.
I believe they did. And then had regrets for doing so. And
And your client didn't mention that he had pled guilty when he hired you?
he did not. I don't think he fully understands what was going on. He's not sophisticated in the ways of court. And again, had never seen discovery, which was his biggest issue. Which is why when he hired me, I immediately filed for discovery. The original trial counsel is not easy to get a hold of. I do see him in courts all over southwestern Ohio, but did not see him in the interim time between being hired.
So you're suggesting that your client had no idea what was going on when the trial court was going through the whole colloquy regarding the guilty plea?
I can't speak to his mind.
Well, you can because you talked to him, right?
I did talk to him. He never indicated to me that he had entered a plea. What he kept reiterating was that he didn't know anything about his case.
What could the trial court have done differently then in the plea hearing to ensure that he understood that he was pleading guilty? Now, there's no transcript in front of us, so we have to presume the regularity, but I guess if assuming that the trial court went through the standard plea colloquy, why isn't that enough?
Well, I think the Rule 11 sets forth the minimums, and I don't deny that the trial court went through the necessary requirements of Rule 11. Could he have asked if he's seen discovery? He could have, but he's not required to, and quite frankly, I've never seen any trial court ask that. To me, there was no harm in allowing the plea to be withdrawn, kicking it over for 2 weeks so I could get and review the discovery, and maybe it would have ended up in the same place. Maybe not.
Well, I mean, isn't the harm that you don't have finality of these types of cases when somebody pleads guilty? If they're able to withdraw at will, then that plea doesn't mean anything, does it?
It doesn't, but item number 8, whether the defendant was possibly not guilty of the charges, had a complete defense to the charges. I don't know whether he was possibly not guilty. It doesn't say definitely not guilty.
Did you get the discovery?
I never did get the discovery. And the trial court went straight into sentencing. There was an unrelated other traffic case that he was sentenced on that we did not have an argument for, and I wasn't arguing that one. It was just the TRC number that I was hoping to withdraw the plea on so I could review the discovery. It's not 1990 anymore. There's virtually body-worn camera on it. Just about every officer out there, as we know. It's available the next day, oftentimes in the media, unfortunately. It would not have taken long for the prosecutor to provide discovery to me if it was ever provided to the original counsel. I can assume that it was, but I don't know, and quite frankly, we know what happens when one assumes. So and I understand there's the Supreme Court has been a little more adamant recently about timelines, but another 2 weeks in the interest of justice would not have been asking for much or any time, quite frankly, for me to get discovery. And with electronics the way it is, discovery could have been provided immediately or within a day or two of it being requested.
But theoretically, if there was a defense in that discovery, then that 2 weeks would have turned into something much more. If there was that defense that
In the interest of justice.
factor number 8.
In the interest of justice, I would hope so.
Of the 9 factors, which do you think weigh in favor of your client?
Particularly number 8, whether he is possibly not guilty, whether the motion was made within a reasonable time. As soon as I realized that it was set for sentencing, I filed it immediately. Whether the motion set out specific reasons for the withdrawal. Again,
Well, what were the specific reasons? I'm that he I'm still struggling with, he didn't understand what was going on.
He didn't understand the merits of the case. He had not been given a chance to consider the merits of the case. Was he, what would the video have shown? And we don't know that. Whether the state would have been prejudiced by the withdrawal of the plea, I don't see how there would have been any prejudice in continuing the matter for a couple of weeks or longer if it was discovered that there were merits in the video or in the rest of the discovery that were worth litigating. So, as we're aware from the Supreme Court, cases have taken, in some instances, way too long for too little reasons, but cases that have merit should get the appropriate time that they deserve. Quite frankly, I think whether the defendant was represented by highly competent counsel, his original trial counsel is highly competent in some matters. At the risk of patting my own back, again, I've handled thousands of OVI cases. I think there's only a handful of attorneys in southwestern Ohio that have the level of experience and knowledge that I have in this particular type of case. Unfortunately, the Supreme Court hasn't seen it fit to allow us to specialize in the area of OVI, despite the fact that there's probably 100 times more science involved in most OVIs than there is in a routine murder case.
Your time has expired.
Thank you.
Whenever you're ready.
May it please the court, counsel. Neil had a change of heart, and that is not a sufficient reason to withdraw a guilty plea. If Neil had an issue with his guilty plea, he would have certainly communicated the information to Mr. Meadows when he retained him, and he did not.
Counsel, how do you respond to this suggestion that 2 weeks would not be that big of a deal in the interest of justice?
2 weeks in terms of delaying finality, the state would agree. The prejudice to the state would have been minimal with a 2-week delay.
So why not allow him to withdraw, allow the discovery to be provided, and justice to be had?
Because Mr. Neal was provided a full and just process in the system.
He says counsel for Mr. Neal says he was not, because he wasn't provided discovery. And it would have only been 2 weeks to allow justice to prevail.
Well, he did not disclose the discovery piece to the trial court. So in the motion, the written motion to withdraw a guilty plea, it just said that his client had not gotten a full discussion with his attorney over the merits of the case. And when the judge asked him to expand upon that, he said, "I was hired midstream." So there was no statement, oh, he didn't go over discovery with him, his trial court's performance was deficient. It was, I just didn't know that he had entered the guilty plea.
So did they forfeit that argument because they didn't bring it in front of the trial court?
I do think they forfeited any further consideration to their argument once they did not provide additional information. The court can only deal with what is provided to them, what is set before them. If he did not set before the court that issue that he was not in full communication, he wasn't being fully disclosing the information, discovery, the court can address it. So I do think it is forfeit at that point.
So that's all discussed in the actual sentencing hearing date? Because that's when the motion to withdraw or the motion to withdraw the plea was heard?
Right, so there was an oral motion on October 29th of 2024, and then the written motion that was filed on November 1st, which was when the date the sentencing hearing was continued to. And in that motion, there was one sentence referring to the deficiency of trial counsel, or Carl Lewis's representation.
And really, it was more in the nature of, I've got new counsel needs more time.
Right. You're accurate, Your Honor. So the transcript of the plea hearing itself was not ordered for this appeal, and that does not provide the court the opportunity to actually read the Rule 11 colloquy, the actual questions that were answered. Usually in those Rule 11 colloquies, the trial court will ask, were you satisfied with your representation? And at that point, I will assume that Mr. Neal said he was because the plea was entered. The trial judge would not have allowed him to enter a plea of guilty if he would have said to the trial court, my attorney did not go over discovery with me.
So we need to, because there was no transcript, we have to presume the regularity of the proceedings, correct?
That is correct, Your Honor.
So we need to presume that the trial court did ask all of those questions, including, were you satisfied with your counsel? And that the defendant answered affirmatively, correct?
Yes, Your Honor.
And presumably, a transcript could have been produced, it just was not for this proceeding.
It was not. So specific dates were ordered, so October 29th and then November 1st. I mean, I can't speak to counsel why they specifically ordered certain dates, but they could have ordered the full transcript, which would have allowed this court the opportunity to get a feeling of Mr. Lewis's representation in general, not just those two hearings that were requested. So as Judge Brock stated earlier, this is an abuse of discretion standard of review. And nothing about the trial court's performance was unreasonable or unconscionable in any way. They responded to the arguments set before them appropriately. And I'm sure every defendant has a wonder or thought, could I get a better outcome with a different attorney? But that is not grounds to withdraw a guilty plea. Unless there are any further questions from the court, the state will see the remainder of its time. All right.
Okay, thank you. Mr. Meadows?
Just very briefly, Your Honors. The Rule 11 colloquy is just one of the 9 issues that the court's considered. And I don't dispute that there was an appropriate Rule 11 colloquy that took place. Quite frankly, in 28 years, I don't recall ever not going through that colloquy at a plea hearing, in particular in this particular trial court. That we
Now,
were-
counsel, you didn't raise any ineffective assistance claim on this appeal, is that correct?
I did not.
Okay. So
28
you're not suggesting that Mr. Lewis was ineffective?
There's other attorneys that are much better suited for suggesting that attorneys didn't do their job. And
I'm sorry, I'm not following. You didn't suggest that Mr. Lewis didn't do his job?
yeah, I'll say it again.
And I'm not trying to put you in a position where you're critical of Mr. I'm just,
Yes.
in terms of claims before this court, ineffective assistance is not one of them. Is that correct?
According to Mr. Neal, the discovery was not shared with him.
And I'm sorry, I'm just, in terms of the issues on appeal, ineffective assistance is not one of the issues before us.
Correct.
Okay.
And, yeah, I have a tremendous amount of respect for Mr. Lewis. I consider him a professional friend. We don't socialize together, but I'm not in the habit of throwing attorneys under the bus, especially on the record. And I don't know what was in his mind during the original handling of the case until I was hired to replace him.
So even though the Rule 11 colloquy is not on the record, we know that the oral motion and the actual hearing on the motion to withdraw the plea are there in the record. In either of those, is the lack of discovery discussed in any, from your perspective, in any substantive way? Or is it more in the nature of, he has new counsel, I just need some more time?
I think it's implied in my statement that Mr. Neal didn't feel he was being fully advised of the merits of the case. And again, I was careful not to suggest that any attorney was ineffective or not doing what they were supposed to, other than not fully advising Mr. Neal of the merits. And I hope that answered your question.
It does.
Thank you. Does the board have any other questions?
Nothing here?
Thank you.
Thank
All
you.
right. Thank you both for your time today, and we will issue a decision in the next few months. Thank you. Would you like to reserve any time?
Yes, I would. Your Honor, can you remind me, just so I'm clear, how much time are we given?
You have 15 minutes total?
5 minutes, please.
Great, okay.
Thank you. May it please the court. Your Honors, I appreciate the opportunity for you to hear this. This case involves the court's first several areas of appeal, but the first issue I want to get into is the classification of marital property versus separate property and how the court handled that in relation to the evidence that was presented in this case. Here we had a case where husband had owned some property in California. We had called those California properties that were shown, and that was prior to the marriage. And then the proceeds of that money was placed and used to purchase a property that we're calling the Harness Street properties. And in those properties were purchased prior to the marriage. What the court would see is that several interspousal deeds were done throughout that period. I believe there were 4 interspousal deeds. And then ultimately, the Harness Street property was sold to purchase.
What was the timing of the deeds? Were the deeds during the marriage?
Some of the deeds were during the marriage. There was interspousal deeds in both, I believe, both during and prior. There were a total of 4 that were issued. Yes, obviously the interspousal deeds were at the time he purchased the property. The Harness property was all purchased during the marriage.
Was
So-
wife represented by counsel during the interspousal deed transaction?
Wife was not represented by counsel.
Was husband?
No, husband was not either.
Were the interspousal deeds valid under Ohio law at the time?
They were valid under California law. The properties were California properties, and the parties were residing in California, or they resided in Ohio and California on separate times. So they were all executed in California.
My question, though, was with respect to Ohio law, were those interspousal deeds valid at the time?
I see no deficiencies in the interspousal deeds that would make them invalid. They conformed with the requirements to be signed before a notary and understanding what they were. They clearly articulate what they were. So I don't honestly think that the interspousal deed is dispositive of the issue. However, this is just more of a note that what we have here is we have California properties, money going from there that's clearly separate prior to the marriage, quickly used and sold and put into the Harness Street property. And then the question is, the Harness Street property is sold and placed, and then almost immediately, I believe 3 months later, used to purchase the Phelps property.
But your client performed work on the Harness property to increase its value, is that right?
Well, I mean, I would disagree with that, with the finding that there was any work done. There was minimal work done, and certainly no work that could be done that would be characterized as improving the value of the property to any certain degree. What was talked about is removal of certain debris and things like that. That is not anything that would increase the value, more upkeep of the property or maintenance.
Did your client have a job other than the work he was doing on the Harness property at the time?
At that time, no, he did not.
Okay,
Did
but, go ahead.
the Harness property sell for more after they disposed of it and bought the Phelps property?
Did he make money in he did. There was appreciation of the Harness property. And the issue, and I think the issue there is, what is that appreciation properly characterized as? And I think what I did is certainly in the reply brief is analyzed what is really required. And I think that we produced evidence. There's no evidence that any work was done to increase the value of the property. Courts have, and essentially, opposing sides' argument is, well, you haven't proven that all of this money was passive appreciation. That was passive appreciation. And certainly, there's no way of proving that all the money is passive appreciation, but the lack of any additional work done to increase the value would indicate passive appreciation.
Counsel, I've got a note here that your client installed cabinets, he painted, he excavated debris, and completed tile work on this Harness Street property. Is that accurate?
I don't believe that. I think that the The question was, I know that there was testimony regarding excavation, and I think the tile work was in general to what he does, what he has the capability of doing on other properties. There's other properties that were in this, that are in this case. There's 4 or 5 other properties. This is what he's qualified to do, what he does on the properties that he owns as a landlord.
Well, if that's what he does, and it was during the marriage, and if, you know, the family income that was paying the bills came from her working, I guess I don't understand how that's not a joint effort.
That is not what was done on the Harness property. The question was, what type of work does he do on the properties that he owned, what he has the capability of doing? And he testified that he has the capability of doing basic plumbing, replacing a toilet, repairing tile work. Repairing of tile work is not a situation that would increase the value in any sort of, it is maintenance type work unless it's shown to have increased the value. The court regularly deals with issues.
What do you mean if it's shown? The property sold for more than what he bought it for, so doesn't that show that the property increased in value?
Well,
What else do we
it
need to
does show
see?
that it increased in value. The question is whether that increase in value is attributable to the passive appreciation of a property, which we have all seen in the last, I don't know, 5 to 10 years, tremendous increases in value of properties. However, that does not mean that that is due to the labor of any person who is the owner.
But your client
Yes,
bears that burden of demonstrating that all of the appreciation was passive, and none of the effort that he put in led to the.
well, I mean, that does raise the question. I think the
Is
issue
that,
is,
I'm sorry, Counsel, is
Oh,
that
sorry.
correct?
Apologize.
Does your client bear that burden?
he bears the burden of showing the appreciation and how that could be characterized. Now, that doesn't mean that the burden involves in excluding any possible other means of appreciation. Those were never shown at all, and there was nothing to rebut. I think we cited several examples where the court addresses the issue of this specifically. This is the 12th District in Patterson v. Patterson. The trial court found that no evidence has been presented to allow the court to determine specifically how much the principal on the residence was reduced using marital funds. Under such circumstances, the trial court refused to speculate, and the court found that that was proper.
Well, let me ask this, Counsel. Your client was not working at the time.
He was not working.
Wife was working at the time,
Yes.
supplying income to
Yes.
the household. Did that help your client to maintain and develop this Harness property?
No, there was no testimony to that effect. Did it help him to live? I think it most certainly did, but the funds, this was owned in co-ownership with another party, and all expenses were paid through the use of an LLC, of a California LLC. And there was never any evidence or produced that any marital funds were used to support that Harness property.
But marital funds were used to allow your client to eat, to live
eat.
somewhere, correct?
Yeah, but that, yeah.
And so he could fiddle with the Harness property because the wife was working, right?
That's absolutely true. But that's not a factor for the court to determine.
There's no value in the wife allowing the husband to pursue this Harness
Well,
property?
there certainly is value in it, but it's not a value for the purpose of evaluating whether or not property has changed from separate to marital.
What's the standard of review in terms of, it seems like the judge was basically saying, if you look at all these funds, basically they accrue to the benefit of both parties in the marriage, one way or another, through the tracing of the various properties. What is our standard of review in regards to that determination?
So essentially two standards of review, I believe. The first would be whether just the court distributing assets would be an abuse of discretion, but it's manifest weight as it relates to classification of the marital versus separate.
That's a pretty high bar to jump over. So basically, you would have to find that the court made a very obvious error, and can you explain how we would get to that? I mean, there was some evidence on, going to the wife's work here and the wife's presence contributed to that property. So how would we get to finding that it was contrary to the manifest weight?
Well, there was not evidence that wife contributed to the property itself. There was evidence that wife contributed to the financial means. I think her testimony was that she was at the house and would get items for the people while they were doing a little bit of work on the property. So, I mean, if it did contribute to the value, it is certainly a de minimis contribution.
When the rental properties were being held, how were they mortgaged?
The rental, yes.
And how were those mortgages paid?
You'll have to, the mortgage is paid for the Harness property, specifically is what I'm talking about right now. Those were paid through the tenants that
And then was there income that accrued to their joint tax accounts from those properties?
There was no evidence presented of income. There was capital gains that were earned during the period.
All right.
There
And they
certainly were.
both paid taxes on that?
They did, yes, they filed married.
So the proceeds of the properties were treated as joint income?
Your Honor, I do not have an exact answer for how that would transfer in terms of a Schedule K coming over and how that's handled, but he would have got a Schedule K for.
And it seems like they would have a complex financial arrangement where she's earning income, his properties, separate properties are earning income, but the proceeds from each are being treated as joint income for the purpose of federal taxation?
I would certainly agree with that, but I would argue this the same way that the court sees every day in these types of situations. This is where a person is, through a will of a family member, is given an asset that is an account, a stock account. That account goes up in values, receives dividends. Those are taxed. Just because it stays in that account, that remains marital funds regardless of whether or not the parties are paying taxes on the income of that property. I think that's
It's my
the issue.
understanding at some point she received some sort of wrongful death
She did, yes.
settlement. What happened to that fund?
Well, the evidence from that is that she was going through a dispute in Jordan with her family, expended considerable amount of funds to hire a lawyer to dispute those funds. And in terms of what the court did not get into, and this is what what the court really didn't address, and I'll tell you how the court got around addressing the issue of our expert report, is the trial court said that basically because mother worked, raised the child, and contributed to the household, therefore it's not separate property, it's changed value. Well, that certainly wasn't the case. The child wasn't even born. But then that gets us to the Phelps property, which is where the extensive use of the tracing was used. And the trial court really didn't go into any sort of evaluation as to the legitimacy of that report, really said that on cross-examination that our expert, he agreed that there could be mistakes in this report. However, and if those were found to be true, there would be an error in the ultimate calculation.
Counselor, your time is past expired. Thank you. I gave him about 3 extra minutes, so I will also give you about 3 extra minutes.
Thank you, Your Honor. Appreciate that. May it please the court, again, was Dan Zrasat, counsel for Christina Shtaywe. I was selected for the difficulty of my last name in order to be consistent with everyone else. So, Your Honors, this was a marriage of very short duration, but as you've noted, there were significant changes both in terms of the asset acquisition and commingling of those assets that occurred. And the presumption in divorce cases, as you know, is that the assets acquired during the marriage are marital unless proven to be otherwise. Husband here asserted the claims of separate property. It was his obligation to prove by preponderance of the evidence that they were separate to begin with, to trace that separate property, and to reflect that any appreciation was due to passive appreciation. If he failed to provide adequate evidence of that, he failed to meet his burden of tracing and the appreciation, and therefore is not entitled to that. It's
Counsel?
important. Yes, Your Honor.
So what did your client do to help increase the value of the Harness property? Because that seems to be at the core of everything else that flowed from
So,
it.
Your Honor, I would say several things. It's not just what she did, it's what he did. As the court noted, it was his full-time job. And as the court will see in the record, his work within that time period was able to, his profits, if you will, from the prior entity, from the prior properties that he held until the sale of Harness went up almost 60% in about a year and a half. So I think it's pretty obvious that there was an increase in the value of the asset that was related to the work that was being done there. That's what the court found.
I mean, how do we differentiate that from market forces, that the property values just went up without anything necessarily being done to it, this passive appreciation?
So
that's
two
just-
things, Your Honor. First and foremost, it's that the Harness property itself was not his before the marriage. So I think we need to delineate. The presumption here is that it was a marital property. It was his obligation to prove that it was separate because, again, what he's referring to is that he owned other properties, not the Harness property, other properties prior to the marriage. He held those properties during the marriage, and there was no evidence presented as to how those were handled or how the payments were made, et cetera. His only documentary evidence was to provide that there was a 1031 exchange, a like-kind exchange used so that the gains from those properties were rolled into Harness. However, Harness itself was from the outset a marital property, and it was his obligation to prove that it was separate. Our position is that he never established that. And aside from that, not only did he not establish that it was presumptively separate, he was not able to trace those funds in sufficient detail and certainly did not trace the passive appreciation because, again, it was his obligation to prove that it was his separate property and to prove that what portion of that presumptively marital asset, since it was acquired during the marriage, was his. In this instance, he did not provide that evidence. That's the bottom line, is that the court found that he didn't do that. He sort of skipped past all this. I will tell you that in the trial, really the evidence that he presented, and again, as counsel will note, that it's not just your testimony. In this case, we obviously look for more than just testimony by each party, that there needed to be some documentary evidence. His only documentary evidence provided as to how those prior California properties were handled, and the testimony that he just recited to you in terms of there was evidence that the LLC paid for the expenses and the mortgage and whatnot. That was just testimony. There was no records provided of that. The only evidence that was provided all the way leading up to the Harness Street property was these interspousal deeds, which to your question, Your Honor, no, our position is that those would have been violative of Ohio law to the extent that he's seeking to rely on them in that regard.
Weren't they signed were they signed in California?
They were signed in California, but he's using them in this instance to state that they were effectively an agreement after the fact. In fact, the testimony at trial was that, he claimed that they had always discussed that these would be his separate properties, and therefore the deeds basically were a documentation of this prenup. And that is not the case, and certainly if that was disputed, but even if it was undisputed that that was the case, then he was basically trying to use those deeds as effectively an agreement between husband and wife as to the characterization of assets, whether they're marital or non-marital, which under Ohio law at the time is against, you're only entitled to do that in a separation agreement. You're not entitled to do that. It was effectively a postnuptial, sought to do it.
Did your client testify that she was aware what the purpose of those interspousal deeds was?
She actually testified the opposite, Your Honor, that she was, now just to set the scene here, this is immediately after she had lost both her parents and a godfather in two terrible car accidents. So as she testified, she was completely in shock and had basically relied on him. He said, this is something we need to do for tax purposes. She signed it.
So related to that, I don't mean to cut you off, but that's what you got the wrongful death check for? The settlement check?
Yes.
And then, so how was that property treated? Did that accrue to both of them, or?
So, Your Honor, you asked that question of counsel. He testified that the money was used up for some additional attorney's fees in Jordan. That was not the testimony. In fact, the testimony was that she had she obtained a $114,000 settlement of that wrongful death claim, clearly separate property under Ohio law. And she put it into an account that husband directed her to put it in his name, saying this will be a much better interest rate. And her testimony was that that was going to be not touched, that money would sit there, earn this great interest rate until they could agree on what to do. It wasn't until she got into the divorce and got into discovery and realized that literally the day after she had put that money into the account, he had moved it out and then began using it to do all sorts of things that she didn't know about until the divorce proceeding, and she got the discovery and was able to see that that check literally went in one day and out because it went into an account only in his name and then went out the other day. And therefore, there was no separate, basically the court then said that also there was no claim for those separate proceeds. So as part of this, the court was faced with a short marriage with a significant amount of back and forth, really a dizzying array of transactions back and forth. And the court ultimately said, all of this is going to be marital. They're both from a perspective of you didn't establish the basis that you needed to in terms of really proving this was marital and tracing it, more importantly, tracing it. We've had a lot of discussion about the Harness property, but even if you presume that the Harness property was largely or in part separate, the bigger issue then is there was not the sufficient tracing into current assets, and that was the issue. So when we talk about the court took issue with the expert's report not because there were theoretical potential assumptions made, it was because there was testimony that he had failed to do certain things, because the court could follow where the assumptions he claimed he was applying were not applied consistently. In the closing argument that I presented, I went through detailed examples in his report of where he was not following the rules he claimed to have provided. He wasn't taking into account the facts or some of the other relevant considerations and was simply just presenting and therefore the court ultimately said, you're correct. This does not do that which is required to do, which is to fully trace what these assets are today.
Counsel, sorry to jump in. I'm going to switch topics before your time runs out and talk about this life insurance policy.
Yes, Your Honor.
So the court ordered the appellant to get a $500,000 policy. And my understanding is that would result in more than what he was obligated to pay under the court's order. Is that correct?
Your Honor, he was not ordered to obtain a policy. He held such a policy, and the court simply asked that he direct wife to be the designee for the life insurance proceeds. So it was an asset that he already owned and maintained.
But he had to keep it.
Yes, but
And wouldn't that result in him paying more, wife receiving more than what she was entitled to under the court's child support order?
not at this point, Your Honor, because if you calculate the child support order plus his obligations for the medical expenses and additional costs that were associated with that, that would not be in excess at this point. Could it in subsequent years potentially be too much? And as we said, that's as simple as the court saying that can be reduced as the child support obligation then reduces. That's not a major issue, but as it stands today, it actually would be if you calculate the support that's owed, because he's a very young child, so I believe it was 4 at the time that the court entered its order, and there was between the child support order, the calculation of the insurance premiums that were necessary because father was obligated to insure the child with medical insurance, and the medical expenses as a result of the insurance that he held would easily come up to about $500,000.
And did the trial court do that calculation in determining that he needed to maintain this $500,000 policy? Is that in the record?
That calculation is not in the record, although that evidence was certainly available to the court in terms of the court had already seen both the expenses associated with the child's health insurance. We had testimony about the fact that there was effectively catastrophic health insurance coverage that was being made available, so virtually everything was paid out of pocket. So that there was.
Do you know what the premium is on that?
The premium was $780 annually, I believe.
So not that much on a monthly basis.
No, no.
So if I'm understanding correctly, the child support order was deviated upward because to account for the child's expenses as far as the, like you said, out-of-pocket costs as well as activities and private school tuition, correct?
So it was multiple issues. The biggest chunk of it was because of the tuition, the private school tuition, which again, there was testimony that the parties had both agreed to that school previously. In fact, leading up to the trial, husband had been bearing 50% of the tuition costs, and now, after the trial, meaning for the next school year, it was anticipated that the tuition costs were actually going to go down because mother would then qualified for some scholarships. So the tuition cost was actually going to decrease from what the parties had already voluntarily agreed to cover equally. So that was a chunk, that was a piece of it. Another piece was the childcare expenses, because as the record will show, father effectively went from 50-50 time to deciding that he was going to spend less than 2 weeks total time per year, so that mother was effectively a full-time single parent to bear all the expenses and was going to need significant child care in order to do that. So that was an additional component, particularly because she wanted to maintain the child in the school where he goes to school, because and the court found that it was in his best interest to continue in that stability given everything else that was going on in his world. Only $127 a month of that entire cost was actually the so-called prepaid dollars for the extracurricular activities. That was for 2 activities that had been agreed upon, and historically the numbers were available in terms of what those are. And I will note that the court did that in part because of the contentiousness of this case, because of the fact that in every instance we have had to file motions for contempt for father to meet his expenses. In fact, the court's records will show that just last week we were on a motion for contempt for exactly the same issue, the medical
You can't
expenses.
consider that.
I understand that. I'm just
Counsel,
saying.
and I'm sorry again to take up more of your time. On the cryptocurrency
Yes, Your
piece
Honor.
of it, was it the same, I don't know what you call these things, was it the same type of currency that was split up? In other words, did they have, I'm making this up, 10 Bitcoins and the court split it 5 and 5? Or did they have Bitcoin and Polkadot and Ethereum, different types of?
There were multiple types, so there were multiple cryptocurrencies that were listed. So there were several wallets and a Binance account that held some of those cryptocurrencies.
And how did the court split those coins
The
up?
court ordered those to be divided in kind, and that's very common, Your Honor. It did the same with the investment accounts. And it's interesting that that the appellant's objection in that regard is claiming that it was not definable, but the answer is it's definable in the exact same way that investment, retirement, and IRA accounts are. You are dividing in kind as of X date, the holdings as of this date to be divided in kind. That's
So
what he
for
was ordered to do.
each wallet, the court said husband gets half, wife gets half?
Correct, Your Honor.
It wasn't, okay.
Correct. And so the reason for that, quite frankly, is that there was such volatility. In fact, those dollars are up, again, not that it's to be considered by the court, but the trial court specifically noted the volatility, the additional volatility in the crypto market, because I will note that appellant has taken issue with the in-kind division of the crypto, but not the in-kind division of the investment accounts, even though it's the same issue for both, meaning the court ordered both to be divided based on the holdings as of a certain date at a certain time, and both parties would receive the holdings as of that date. In the crypto circumstance, the value has quintupled in the time frame that is relevant just because of the volatility of that market, which is why the court directed that it be divided in kind rather than set a value that frankly was a year and a half out of date by the time we went to trial. Your Honors, at the end of the day, what I would ask you to do is focus on both the standard here, which is an abuse of discretion, and more importantly, that in every scenario in this instance, this court is the court in this case frankly set out an orderly and reasoned decision that went through not just the specifics of husband's failure to meet his obligations, again, because whether it was Harness property or Phelps, the bottom line is each of these was presumed to be marital, and it was his obligation to prove to a level of certainty by preponderance of evidence that this was the appropriate division, that this was his share. Instead, husband has sort of skipped a few steps and then is come to you to say, well, if that didn't work, how about you at least give me X? How about you at least give me Y? Even though by his calculations, even if he's seeking that you now find that the Phelps deposits, for example, were his separate property. This despite the fact that, as we've shown in our brief, even if you take it as a given that the Harness property proceeds were entirely separate, which again, I would say to you, he did not prove, and he certainly didn't prove to the court's satisfaction, then the answer is, even the calculations that were associated, the court certainly found that Mr. Kuvin's calculations were incorrect and were riddled with errors that we've also pointed out in our appellate brief here.
So there was competing testimony about we'll focus on Phelps for a second. There's competing testimony about the value increasing because of wife's contributions, be it the fact that she was working and supporting the family or that she was contributing to the mortgage. So there was competing testimony on that?
There was competing testimony as to that, because certainly husband tried to frankly dismiss the efforts of wife, although again, there was clear testimony that husband himself was engaging in this effort. So I want to focus on it. It didn't, as you know, the appreciation can also result from husband's active management, active appreciation, et cetera. And in this instance, it was clear that he was doing so, as Your Honor noted, during the time period for the Harness Street property in particular. That was his entire job. That's what he did, is that he did not hold down another job. He was actively engaged in managing and dealing with this property. He was a real estate developer, as he would try to say to you, and that was basically his job, his engagement. So there was testimony to that effect. The court found more credible wife's testimony. But again, the more relevant component here is that husband did not meet his obligation to prove these things separate. The court reviewed this on a variety of considerations, both in terms of what his obligation was, but also looked at this equitably, because at the end of the day, the court is required, even if he had managed to resolve all of those issues. So even if the court erred, as he claimed, by saying that the Harness Street proceeds were not marital, even if that was an error of the court, as you can see, the court nonetheless had other reasons why it believed that it was equitable to divide the assets as it did, not the least of which was the fact that these parties, aside from commingling that had hopelessly entangled them and did not allow the court to disentangle specific dollars here, but also that wife had so contributed in other ways during the marriage, had contributed her own separate property, et cetera, that ultimately the court felt that it was equitable in this marriage for the parties to divide the properties, the marital property equally, as it did.
Your time has expired unless there's more questions from the panel.
Thank you, Your Honor.
Okay, thank you. You have about 5.5 minutes.
Thank you, Your Honor. Just specifically to address the issue of the adequacy of the evidence in tracing of the Harness property, what was presented is the IRS 1031 exchanges that clearly showed X property was sold at the California property and then used to purchase, the proceeds thereon were used to purchase this Harness property. I don't know what more way could be used to clearly identify where the funds came from and where the funds went than that 1031 exchange that was testified extensively.
But counsel, isn't the issue the appreciation of the Harness Street property during the course of the marriage? So he bought it for, I'm making up numbers here, $100,000. He sold it for $300,000. That $200,000 in appreciation occurred during the marriage. Is that correct?
That is correct, Your Honor.
And would your client have been able to do what he did with the Harness Street but for the wife's support?
Absolutely, Your Honor.
What was the period of time? I'm sorry.
So
Excuse me?
he, and I'm confused when you say absolutely, he was not working.
Your
How
Honor,
would he have earned income without the wife's support?
he had been employed in the same field throughout
He was
that
not
time.
working at the time.
Correct. I mean, he had funds, Your Honor. He had income, that he had assets that he had throughout the marriage. He was not someone without assets at the time.
But he didn't have to use those assets because the wife was working and supporting him.
I would agree that there may have been assets that he would have spent had wife not have been working. That is not how a couple expends their money during a marriage is not the determination I think that the court has used historically in any case I've seen into whether or not, because money was spent over here, then therefore this property can't be separate and doesn't maintain its separate interest. I think that would be the equitable concern that the court could do in some sort of distributive award later on, but the court didn't get to that issue. So I would maintain that the fact that husband was not working and wife was working is not determinative of the issue of whether separate property maintains a separate status.
So, I'm sorry, did he finish?
I'm finished.
Okay, so the harness property was sold fair in 2018, correct?
2018 and
Yeah, and so then he bought the Phelps properties.
3 months later, yes, I believe
Okay.
in February of 19.
How were the mortgages paid on the Phelps properties?
The Phelps properties were paid, it was owned in the testimony from husband was the payments were made through the income that was received for tenants being in the property.
So was there competing testimony that the mortgages were paid through the couple's bank accounts or any accounts?
There certainly was completing argument after the fact. I do not recall any competing testimony of that nature, and there certainly was not any competing, there wasn't any evidence in all of the detailed financial records that were presented that show money going from these joint accounts into the Phelps property.
Okay, thank you.
What was the period of time of the appreciation for the harness property?
Oh, Your Honor, I believe it was about roughly not, if it was more than 2 years, it wasn't much more, but it was maybe less than 2 years. So in that, it was a short period of time.
And it was a 60% increase in the value?
That's correct. Your Honor, I do want to address the issue of the child support and the deviation that the court got into with opposing counsel. And I think the interesting thing that the court went into was not only the upward deviation of the income, but then these expenses that were required. I think the expenses that were required to be paid based upon the assertions that they would be incurred. I think the court has a standard to address whether or not the court properly went through the factors in upwardly deviating the child support. I don't think that the court did in evaluating the ability of the people to make these payments. So this is a case where he earns $55,000 a year. They did an upward deviation due to the income that he has on paper for the rental properties that he owned, and then also re-put in the depreciation, gets him to $90,000. Interestingly, wife was awarded and maintained a property. The court didn't do the same in that. They only did it for one side. So then they increased his income by about 50%, and then also deviate upwards his obligation by about $1,200 a month. And it's hard to believe that this is anything but punitive in nature. I don't believe it was justified, and the court didn't go through the factors.
Okay, but she pretty much alone is caring for this child and is, has to pay for the child's food, has to pay for books and toys and everything else. I mean, she has this child almost full-time.
Yes, Your Honor.
I'm struggling to understand how it would be inequitable to award her a larger child support amount.
Well, I don't argue that it perhaps could be equitable to do that. I think that an increase of, let's see, probably $300 by the end, $300 to $400 because of the increase in his income, in his wages, in his actual income, and then $1,200 in terms of additional deviation upwards.
But doesn't that account for example, the tuition and for the out-of-pocket medical costs?
If those expenses were in fact incurred, which there was not evidence that those were incurred. or
There wasn't any evidence that,
that
tuition had to be
previously
paid?
paid tuition,
okay.
not that what the tuition would be for the next year. That was not, it was saying it could be $15,000, I believe, and also another $10,000 for the childcare expenses. Regardless of whether those are paid, there's no mechanism to even identify whether those are.
So the
are
court
actually paid.
can't consider that those would be expenses, and, I mean, there's no way to predict the future and figure out exactly how much tuition is going to be or childcare is going to be. I mean, the court has to make an educated guess at some point, correct?
Yeah, I guess, and then the issue is how do you err? So here, what the court would do is, if it's going to order to pay it additionally, you order that on a monthly basis as incurred, as they do every other expense in the domestic relations divisions. You don't say.
It wasn't part of the reason, the contentious relationship between husband and wife?
I know that was the argument for why it was requested. Perhaps the litigious nature between the parties would be it. I don't know that there wasn't an extreme amount of contention, but there was areas of dispute, but this is not a case that involved these parties fighting amongst themselves through text messages or anything like that. So in terms of a contentious case, this is not one that was contentious. Was it litigated extensively? Yes, it was, but not contentious.
Counsel, what about this $500,000 life insurance policy? Why is that not equitable?
Your Honor, that is not equitable. I relied on case law for that, but that is clearly going to result in a windfall for mother based upon the child support award, and improper because of that, Your Honor. It would order him to pay a great deal more than the child support order. Now, I think the argument is there could be theoretic expenses that make it go higher, but that is not the standard that's outlined in the case law that I reviewed, Your Honor.
So should there be any life insurance in place to cover these actual expenses should the husband die?
We don't believe that it's proper in this case, and we don't believe that the court did the proper analysis to make that finding.
Well, yeah, separate from the proper
Yeah.
analysis, assuming there was a proper analysis, is it appropriate for the court to put this order in place that the husband has to maintain this insurance to make sure that the child's needs are cared for after he's gone?
If that had been the issue as the sole issue, I would say that the $700 largely isn't that big of a required payment. However, when the court looks at it in light of the monthly obligation of approximately $2,050 per month that he is also required to pay due to a significant upward deviation in child support, it is an issue.
So you're saying the life insurance should be in place, the amount was just too high in your opinion?
Well, I think that the language that the Court of Appeals has relied on states that, the Grover versus Jerson case, the trial court found that the court has abused its discretion and to order father to maintain a life insurance to secure his total child support obligation. And then the court goes in and says, assuming arguendo that the securing of the child support obligation of life insurance is, as a policy is permitted, such orders must be structured in a manner that allow the child will only receive that portion of the insurance proceeds equal to the amount of the support he would have received if the parent remained alive. And that calculation certainly wasn't even considered by the court.
So it's the calculation, not the fact that life insurance needs to be maintained is your concern, is that right?
Well, I think there's a question of whether or not it's allowed, it should be done at all. Certainly for this case, I think the question is whether or not the court entertained that evaluation. I don't think it's proper, but.
How would the child's interest be protected if the husband died?
How would the
Without this
child's
policy?
support interest?
Correct.
Well, each parent could secure their own interest with absent a court order, like.
The husband's dead. How is the child going to get support?
I guess it would be through his mother and also through the laws of succession through wills. And
Okay.
he'd be entitled to the assets of the father.
Unless there are more questions, your time has expired.
Thank you, Your Honor.
Okay, thank you.
Thank you.
This case has now been submitted, and we will issue a decision. Thank you so much. That our court has concluded for the day. Enjoy the rest of your day.